What do you say we get this started? It's March 6th, 2026. And, yeah, this is the court gallery. Ladies and gentlemen, we are staying in Michigan for most of the night, with the exception of one Texas case, or set of cases that are quite interesting, actually, with Judge Stevens. But Middleton, he's kind of taking over the Judge Dad's. Yeah, I forgot how to talk. Judge Rossi is good. Simpson's got the coach, and it's all good. I watched most of it. I got news for you. You got a good 2 hours ahead. And guess what? That's right. It all starts right now.
Let's do Mr. Montgomery. He's back there in the lockup. We'll try to get him on his way. I'm going to arraign him on his other charge. Autumn wanted me to do that.
Your Honor, is it possession of a drug double, or is there something else that's charged in there?
I don't even know. Tap that microphone. Laura, we have the same problem we had before. It's not queuing into you, so I'll just do it manually. I'm not sure what's going on. They're about to tear all this stuff out of here within a month or so. Still not working. I just locked it on him.
Oh, okay.
Do you have that file?
No, I checked with district and they indicated you should have everything.
Well, that's the worst case scenario. They gave it to me. I have a felony case. Good morning, Mr. Montgomery. We met yesterday afternoon. Mr. George was here on another matter, and we did a very brief bench warrant arraignment in this case, which is 25278 ST. You're charged with driving suspended second offense. That is a misdemeanor. It's punishable by up to 93 days, up to a year in jail and a fine of up to $1,000. It carries 2 points and it requires that your driver's license be suspended. We did a brief bench warrant arraignment yesterday, as I said, and scheduled the matter for this morning. Mr. George, what's the status here?
The prosecutors offer that if my client would enter a plea to no valid operator's license, the driving suspended second offense would be dismissed.
That's a pretty good offer. No valid operator's license, Mr. Montgomery, is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. Carries 2 points on your driving record and will go on your driving record. Your license is already suspended, but this will go on there. Do you understand?
Yes.
You understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury.
Yes.
If you had a trial, you'd have the right to be represented by an attorney. If you could not afford an attorney, the county could appoint one for you, and they have appointed Mr. George. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
Were you driving a car? Let's look at this ticket again. On February 14th of 2025, about a year ago.
Yeah.
And was your license suspended at that time?
Yes.
You have 2 days of jail credit. You might have some at the front end. He didn't show up last March for Judge Pattison. He issued a bench warrant. And then you got picked up on that bench warrant a couple days ago. You got arrested in June and posted a bond, and then you bugged out again. So you had 1 day in June, 2 days now. Or 7 days jail, credit 3, leaving 4 days to serve, which is going to be concurrent with your new methamphetamine charge, 26360FY. 0 fine. I'm going to waive your attorney fee also. The minimum fee of $125 or 2 additional days, which should be swallowed up by the other time you'll be doing. I believe you owe me money. I had it on yesterday's cheat sheet. You owe money to the court, but I don't have it in front of me for today. We'll look into that in the other case. The new case is 26360FY. And as long as you're here, the magistrate asked me to just take care of this arraignment. That's not right. 25278 ST. Because I didn't have a bunch of other things to do this morning. All right, Mr. Montgomery, let's take a look at your new case. You got arrested on a charge of possession of methamphetamine. That is in file 26360FY. Complaint alleges that that happened in Montville Township on March 4th. Is this the place where you were, they did the search warrant? All right, they charge you with possession of methamphetamine as a second or subsequent offense as a drug double, making it punishable by up to 20 years imprisonment. And you've been in custody since that time. I need to appoint a lawyer for you. They didn't give me the dates. I wish they would do that. I'm going to show a plea of not guilty. I don't even have the authority to take a plea at a felony at this level. To show a plea of not guilty, I will appoint an attorney, set a pre-exam conference. I think the dates are March 17th for the pre-exam and March 20th. The pre-exam would be at 8:30, and if a prelim is needed, it will be March 24th at 1 o'clock. In the underlying case we just did, you failed to appear twice. You failed to appear for your first arraignment. They issued a bench warrant. You actually failed to appear 3 times. Then you did appear and you got arrested in June, and then you failed to appear again, and then you got arrested yesterday or the day before. So in this case, you have appeared, but in previously case you failed to appear. You have an unpaid driving suspended case in 202483 ST. You have an unpaid domestic violence in file 23808 SM. and an unpaid disobeying a stop sign ticket. Failed to appear on the fast, failed to pay fine and costs. And it's a drug double. Set bond at $10,000 cash or surety. They gave me a whole bunch of stuff. Including the bond form. You shall appear personally for any previous or subsequent examination. You shall abide by any judgment entered by this court. You shall not leave the state of Michigan. Do not commit any crime if you are released. Provide email and telephone number on release. Do not use any drugs or alcohol if you are released. No assaultive or threatening behavior. No firearms. You shall seek employment. All right, you're going to be taken back to the jail. The magistrate and the clerk will prepare the bond. If you're able to post it, you need to call your lawyer, make an appointment to discuss this case with them. You've got 4 more days of jail to do on the driving suspended case. I don't think you're going to post the bond. I did not appoint Mr. George as your lawyer. He may end up in the rotation, but I'm not sure who's on duty that particular date. But this takes care of your traffic case and gets your felony methamphetamine case started. You told me you were in bed when the cops came and executed the search warrant. I don't know anything at all about the facts in this case. Your lawyer can explore that further. I suspect there's more to this. There usually is. But you go back to the jail and get lunch.
Thank you.
Good to go. Thank you, Mr. George. This is file 251910, People versus Aaron McDaniel. That's you, sir?
Yes, sir.
You're here on a charge of domestic violence, second offense. Let's look at the, Nicole, is this the case you're here on? This is McDaniel?
No, that's not. I'm paying attention to them all.
Oh, well. Mr. McDaniel, it's alleged that on August 27th, you assaulted Gina Huser, someone you had a dating relationship with, charged as a second or subsequent offense, which is punishable by up to a year in jail. Prosecutors agreed to dismiss that charge for a plea to domestic violence first offense. Domestic violence first offense is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Do you understand the charge?
Yes, sir.
Anybody threaten you to get you to plead to that charge
No, sir.
or promise you anything?
No.
You've signed the advice of rights with consultation with your lawyer, indicating you're giving those rights up by entering this plea. Is that correct?
Yes, sir.
Who is Gina Huser to you?
Ex-girlfriend.
All right, and were you guys living on Chicago Road at that time?
No, sir. We were both homeless. We are
Yeah.
still both homeless.
All right, so this was off Chicago Road by the railroad tracks?
This was by Peterson Spring, or sorry, Iceberg.
Iceberg, all
There's
right.
a factory there. I had a tent back there. She would just come there and stay, and yes.
Yeah, this was in February, so when was this? It was in August, so it wasn't so cold.
No, sir.
So did you get angry with her and knock her down?
Sir, she came back to my tent late at night, heavily intoxicated. She come back, we had a little altercation. I came out of my tent, at which time she pepper sprayed me when I came out of my tent. And out of anger on my part for her pepper spraying me, I picked a bike up and I threw it at her, not intentionally hitting her, but the bike did bounce and it did hit her in the leg. And that was all that occurred at the time. We both settled down. We both went to sleep that night. She woke up the next day. She was looking for a backpack that she lost. She got mad again, and the next day she continued to fight. I never put my hands on her. There was the co-workers at Penguin even stated that I never got off the ground. I just sat there and let her scream. She walked away, and that's when she filed this police report.
Well, one witness says you pushed her down to the ground.
I-
She fell to her knees. While on her knees, McDaniel stood in front of her and used an open hand to hit her in the head multiple times.
I was
At
released
this
that
time,
day.
the witnesses observed the assault.
Yeah, I was released that day, Your Honor, because she had no marks or nothing on her. They just said they were going to run it through the prosecutors. They said that they called Penguin, and they said that they stated that I never put a hand on her, and the officers that arrested
Well,
me.
so do you want to plead to this or not? Did you?
Yes, because I did pick a bike up out of anger, and I did hit her the day previous.
All right.
I did do that to her. Yes, I did. But the holding her down, Your Honor, no, I did not do that. That's why I was released that day from the arresting officers.
All right. You got arrested the first day and you did a day.
Yes. Well, that was following. They released me in August, and then when I was arrested a few
You
months
got
later.
arrested in December.
Yes, sir. I
And you
did
didn't
one
show
day.
up for your arraignment.
Yes, sir. I missed
So
my
you had
court
one
date for
day,
medical.
1 day, then you failed to appear again.
Yes, I called the courts and rescheduled, and
So I think you got 30 days of jail credit.
yes, sir.
You have not done very good on your other stuff.
No,
You have a previous domestic violence where you owed $570 and you didn't pay that. Then you had 3 counts of assault and battery and 24 and you didn't pay that.
yes, I got
So you have
a,
well, you don't have any money, so you
I
don't.
got a job. I just got a job. My boss said if it works out the time served, he said he will be here to get me today to go to the job.
Well, I'm not doing time served.
I
'Cause I gotta get the input from her. Plus, you haven't paid your fines and your costs in your last assault of offenses. And
Yes,
the
sir.
police report reads much differently when your representations were. Had you been drinking when this happened?
No, I don't drink, sir.
Well, that's a plus. Let's see how quickly I can set this. Today is the 6th. Mr. Gibson is set to be here Monday. I don't think you can, she's homeless. I don't think you can find her that fast. Why am I busy?
Your Honor, may I just put a little, I've been homeless for a couple of years now,
Yes, sir.
and this is a really, really good job for me. I've been really trying to get on my feet.
What's the job?
It's in Colon. It's with David Wheeler, really good guy. He just
Doing
got
what?
300 acres of woods and stuff that need to be cleared. He
All
has
right,
me,
well, that can wait.
he has me a place to stay, everything, and
All right, that sounds like a good plan.
yes, and I just won out of Sturgis. It's in Colin, great spot. It's just a great opportunity for
Well,
me.
it's warming up. You've been in
Yes,
jail
sir.
during the coldest months of the year.
Yes, sir.
That's better than something.
I'm just really trying to get on my feet here and trying to do a lot.
Well, you also got 30 days of clean time.
Yes, sir. I mean, this is a great opportunity for me, and he's willing to help me out here, and I really would like to take it.
Miss Hoff's sister is set for last pretrial next Thursday. If I'd had my waterfowl aligned, I would have set her for the same day. Looks like next Thursday is all Luke. Paul, are you available to do the sentence in this next Thursday at 3 o'clock?
I should be. I don't have my calendar in front of me, but I don't think I've got much.
I'm gonna set this for sentencing for 3/12/26 at 3 o'clock. We'll try to get victim input.
You said you can make sure that.
At that point, you'd have about 36 days credit. That may do it, but I want to hear from her, at least have the opportunity to hear from her.
If I can't get that out.
The trees will still be there next Thursday.
I guess the defendant's asking if his bond could be amended to a PR bond and that he would appear at the sentencing date.
The answer is no. He's got $570 worth of unpaid fines and costs from a previous domestic assault and an assault and battery. What I'm probably going to try to do is wipe those fines and costs out when I sentence him next Thursday. Rather than set it for 10 days to the 16th, I crammed it in on the 12th. That's at least gives them an opportunity to try to get a hold of the victim. And I'll see you next Thursday at 3 o'clock. Stuart Udvardy, file number is 2681. Charges no insurance under the insurance code and driving suspended. The prosecutor has agreed for a plea to no proof of insurance, which is a civil infraction. The no insurance charge, Mr. Udvardy, is punishable by up to a year in jail and a fine of not less than $200. No proof of insurance is punishable by a fine only. And that carries a $150 fine. Regarding the ordinance violation of driving suspended, they agree not to charge it as driving suspended second offense, and you would enter a plea to driving suspended. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points, and it would require that your license be further suspended. You understand?
Mm-hmm.
You heard me go through the advice of rights earlier. Do you understand you have those same rights?
Yep.
All right, let's do the insurance case first. Were you driving a car on January 12th here in St. Joe County without having proof of insurance in the car?
Yeah.
All right, that's easy. You'll be $150 fine. By April 6th. So start with that. All right, let's take a look at the ticket here. All right, you got this ticket at 3 o'clock in the morning on January 12th at Broadway and Constantine Street. Are you still working at Metal Technologies?
Yeah,
What were you doing at 3 o'clock in the morning?
I had left work early to go to the hospital because I had an abscess and they ended up taking me to the.
So you work third shift at Metal Technologies. So you're up all night. So 3 o'clock in the morning at Broadway and Constantine is essentially on the way from Metal Technologies to the hospital. You ran the stop sign and they stopped you for driving suspended. Your license is suspended because you keep doing this.
Mhm.
Your license is revoked. You got a ticket on September 15th. You pled guilty to driving suspended on November 7th. You got one in Kalamazoo too. You got one in May of 25, going 89 and a 55. You got one in March of 25, going 80 and a 70 in Allegan County. You got a driving suspended here in April of 2024. Another no proof of insurance in 23. The drinking driving charge, which started all this in 23. Another no insurance in 23. The earlier operating while intoxicated in 20. It's just bad. Previous driving suspendeds, you got about 6 of them. So I don't know, 1,000 million days in jail, does that sound about right? I ask you repeatedly to stop coming in here to see me. It doesn't bother me that you were driving to the hospital because you had a medical emergency. What bothers me is you drive back and forth to work every single day, probably still are.
No,
Did you move to Portage?
I moved back here.
So you're
Got
back with
right.
your parents on Portage Street?
Yeah,
I don't know what to do with you. 1,000 million days is more than I'm allowed to order. I'll say one thing for you, you always pay your fines and costs. You got a bunch of them, but you don't owe me any money. You've got that good job. And I don't want to screw it up, but I don't know what, literally, I don't know what to do with you. You keep driving. You keep driving around with no insurance. You've got about 8 driving suspended convictions, 2 drunk driving convictions, 4 or 5 no insurance convictions. You always pay the fine, but I don't know how to make you stop. Then to make things worse, you work in 3 hours and you move to Portage, knowing you were just going to keep driving. So are you still working thirds at the
Yeah.
foundry? You've been up all night?
yeah.
How'd you get here?
My dad to get me.
So he's sitting outside waiting for you?
Yeah,
He's probably bored to death. How are you getting back forth to work now?
I bought a bike and just either ride the bike or get dropped off at work, depending on the weather.
Are you on probation anywhere else?
No.
Plus you got that other ticket for going 89. I don't know, you really deserve some jail time, but I don't want to make you lose your job. I'm going to ask for some help from the probation department. I'm going to get a pre-sentence report. Rhonda, are you available Monday, April 27th?
Monday, April 27th. I am not. I'm in a neglect jury trial that starts that morning at 8:30 a.m. I'm available the Monday before.
I'll be away. Let's look at the 6th. Monday, April 6th.
No, I won't be back for my wedding.
Oh, yeah, that's right. You've
I'll
got
be
big
back on
things
the
going
10th.
on. Now, how about April 29th?
I can be available in the afternoon.
Well, let's see if you've got a Thursday that you're set to be here.
On April 23rd, I have to be here for pre-trial conferences next door.
That'll probably work. Let's set it for Thursday, April 23rd at 2:30. I want to see whether he pays the no insurance ticket, which I expect that he will. And I want to see if he gets charged of driving suspended again. The hard, cold fact is it's going to be very difficult for you to get your license back. You got the 2 drinking driving cases, which revokes it, and then you keep driving suspended. Which makes it worse. So you just need to get your, and I told you this before, you need to wrap your head around the fact that you can't drive.
Yeah.
Third shift doesn't work good for work release. If I give you a flat 30-day sentence or something, you can lose your job. If I give you 1,000 million days, you'll probably lose your job. Once you take this out to the counter, we're going to get a pre-sentence report and get more information before we do the sentence. You're free to go.
I'm going to do Corbett next since she's in jail.
Okay.
Well, just on that one, she doesn't, her case isn't even closed yet. She hasn't even pled to her case. She's looking for a driver's license restoration.
Yeah, no, well, and it wasn't real, that's not a, she's not a hardship on a, or is she, on a?
She is a hardship.
Is
Yeah,
she a PVT refusal?
It looks like it, but she's also claiming in her form that she didn't refuse that, but they marked it down as her having refused
She
it.
actually did refuse. And even on one of those, they still have to serve the Secretary of State.
Yep, yep.
Yeah, they're the agency that works the
Okay.
revocation. All right.
She definitely has not had a hearing with yet, though.
No.
Okay, we are here in the matter of the people of the state of Michigan versus Edith Corbett, case number 24-04823-FH, and this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court this morning on Ms. Corbett's motion to withdraw her plea or for judicial vacatur of the guilty plea. At this time, I would invite counsel to place your appearances on the record.
Blair Lockman for the people, Your Honor.
Thank you. And Ms. Dagger Margosin, you are muted.
I'm sorry. I'm Janice Dager Margosian for Ms. Corbett.
Thank you, ma'am. And this is your motion. I did read through it, and it appears that the primary basis here is that the factual basis that was elicited during the plea hearing itself did not meet the elements of the charge that Ms. Corbett has pled to and is serving her time on right now. And that specific statute is accepting the earnings of a prostitute, MCL 750.457. And I did read through your brief and the prosecutor's response, and I guess my view of this, particularly in light of the appellate cases that set a somewhat relaxed standard for a judge accepting a factual basis, is I certainly viewed the entirety of the transaction that Miss Corbett was involved in with these customers coming to the massage parlor as a transactional situation where the customer comes in, they pay Miss Corbett the $50, allegedly for the room, but let's be honest, under the facts of the case, it is for access to a room with a young woman who's going to perform a sexual act, and everyone has knowledge of that. And then, she accepts that money. It seems like a stretch to say that's not the earnings or proceeds of prostitution.
Can I respond, Judge?
You may.
Thank you. Well, number one, Judge, I think it's really important here. In light of, and I think the Maury case is really important, that you really do have to look at the language of the statute. Here, Ms. Corbett did not stand there and accept these door fees. So number one, I think the important fact is they were door fees. They were not money obtained from a sex act that was performed. And she was not present at the premises at the time she collected these fees. She collected them at a later time, at a different time, when these sex acts were not going on.
Well, let me just pause you. She wasn't the landlord of these premises. That was someone else. She leased the premises, and this was her business, right? Whether she was present for every moment. And certainly, I think everyone agreed, well, she's not present in the room when the sex act occurs, but that rather it was a scenario where she knew and allegedly, perhaps, to some degree, trained or, prepared these women for the nature of this illicit massage business, right? And further, I don't think that the statute doesn't say you got to be standing there and the prostitute commits the act of prostitution while you watch it and then hands you a portion or some of the money. It just says that the person themselves knows what's happening, and then they accept, receive, levy, or appropriates any money or valuable thing from that act. And I guess the other piece of that is without any consideration given to the person, presumably I'm trying to figure out what in the heck the statute means by consideration here. And the only sense I can make of it is, you're not giving any consideration back to the person who performs the act, but rather you're just taking the money or a portion of the money that comes from, results from the act in a broad sense, the proceeds or earnings. So, I guess, and that's really my thought in looking at the statute entirely is you'd like me to, impose a sequential order that this has to happen in time. And the statutory language to me reads much more broadly than that. It says, hey, if you get your hands on some of this money and you know where it's coming from, you're liable, that's what imposes jeopardy under the act. Am I reading it too broadly?
I think so, Judge. Respectfully, I think that and this is what happened in the Maury case is the Supreme Court looked really, really closely at the words of this statute. I think here you would have to have a situation where Ms. Corbett was receiving money from the prostitutes and knowing at the time she received it that that's what it was from particular sexual acts. Here we don't have that. We have a very generalized set of door fees. So I think the area we're treading into is what
Maury
the
was a little
prosecutors.
different though, because it was the person was more or less who at least, and I didn't read, I just read your summary of Maury, but it sounded like that was a scenario where the person was receiving the calls and then directing the customers to a location to meet with a prostitute. And if there was any money changing hands, it would have been, a separate transaction or not. And in that, is that the kind of the background of Maury?
I think, and I summarized Maury as well as I could for you in the brief, but I think the important part of Maury and what happened at the Michigan Supreme Court level is that court said every single word of that statute has to be observed and complied with by the courts. And we can't. This is the kind of case where you could make inferences upon inferences upon inferences, which the prosecutor relies on in the brief, talking about inferences. But number one, this is a plea, so you got a due process concern of making sure, because you're not having a trial, you're not having a jury find these facts, that the defendant is establishing this guilt. And number two, where the inference upon inference, the old rule of Attlee, I believe it was loosened up in a case called Hardin in 2002, which still said you must have findings that are based upon evidence. You can't speculate. And in this particular case, we're in the realm of speculation. There were door fees collected. Ms. Corbett was not there to collect those fees. She didn't know what was happening in those rooms. There may be times certain things didn't happen. You don't have a transaction where a prostitute goes into a room, does an act, comes out, and turns over her profits. And I think that's, this statute, I think, derived from the times when there were, where prostitution was developing.
Right.
And so you had pimps that were taking fees one-on-one. You don't have that in this case. You have a very generalized setting that she made available. She didn't know what was happening in those rooms. The statute says knowingly that the acts must be profited from knowingly. She didn't do that. She provided a premises. It was known that in general this happened, but she didn't have a one-for-one knowledge that the money she accepted was happening. I don't think that there can be a reasonable inference here. I think you've got inference upon inference upon inference, and I don't think that has any place in plea proceedings, Judge. That's a violation of due process. So that's the summary of my argument.
Well, her own attorney asked her, and I'm on page 9 here of the plea colloquy, Mr. Fabian, you're aware that at least one or more of these independent contractors would perform sexual acts during the massage and in exchange for money.
Correct.
Corbett, yes, sir. I mean, how's that not acknowledging that she knows what's happening in those rooms, whether, she's on the premises at the moment or not?
Well, but I think that, again, what we've got here is a generalized situation. So she is stating that she knows generally this happens. So that would certainly, we would agree, supports having a house of prostitution. She knew this happened, but she wasn't taking earnings as they occurred. She took a very general door fee. The women that did this work got some kind of tip. We don't know how much was tip. We don't know how much was door fee. This was not placed on the record. And so I think that where you have to have some kind of specificity with a plea that complies with the statute, we don't have the knowingly element and we don't have the transactional element. I think those things are clearly missing here.
Okay. All right. No, I think I understand the argument. Let me see if Mr. Lockman has any response in addition to the brief filed.
I would just note under that theory, we would never be able to do this charge because they should argue that they have to know specifically that every dollar that comes in is for this, and that's not what the statute contemplates. I think the court hit the nail on the head. It's right in the brief. She acknowledged that these were independent contracts performing sexual acts during the massage in exchange for money. I don't know how you get more specific than that, and I don't think the courts require more specificity than that. And then she admitted that she collected a fee from every customer that entered there for, in quotes, massage service, which she was aware in many cases were for performance of sexual acts. I think this is, I think it's someone who, after sentencing, has decided they didn't like their sentence and is now looking for a way out and finding this defect. This is not a defect. This is a very clear factual basis that she knew what she was doing, and accepted that fact when she took that plea. And now she's just having buyer's remorse.
Okay. All right. Thank you.
Your Honor, if I could just place on the record, I appreciate that. I hear that from prosecutors pretty often. We don't have any evidence that this is buyer's remorse. What this is someone who had the right to have an attorney overlook her case and view it and see if there are possible issues that were overlooked at the trial level. I don't think disparaging my client is appropriate here. So just want to address that.
Oh, no, I understand. And of course, my entire job is to make sure that, each person that comes in front of me gets the full range of procedure they're entitled to. And a hearing like this is just that. So I don't attribute any of it to, some sort of ill intent on behalf of your client. I know, and I know that you're simply doing your job here as well. And, going over the proceedings, as it needs to be done with a magnifying glass to make sure that, I get it right, because heaven knows, I was just thinking the other day, when I elected, one of the promises I never made was that I would be 100% perfect judge. I just said I was going to, fulfill the oath to the best of my abilities when I'm on the bench. And I appreciate the ability to, legally consider what I'm doing here. However, I will say in this case, I have read the briefing and reviewed the statute, and I don't find a basis for withdrawal of plea or vacatur of my judgment. That would require, finding of a fatal defect, as it were, in the plea proceeding. And essentially, the defect alleged here by Ms. Corbett is that, Judge, you're allowed to draw some inferences in the factual basis of your plea, but you went beyond drawing an inference. You went to rank speculation, as we would call it in the legal world, as to what Ms. Corbett knew, and further as to the sequencing or the economics of the business that she rendered or that she operated on Plainfield Avenue in Grand Rapids, or Grand Rapids Township, as it were. And the statute in question here that Ms. Corbett entered a plea to was Michigan Compiled Law 750.457, which reads, any person who knowingly accepts, receives, levies, or appropriates any money or valuable thing without consideration from the proceeds of the earnings of any person engaged in prostitution, or any person knowing a person to be a prostitute, lives or derives support or maintenance in whole or in part from the earnings of the proceeds of the prostitution of a prostitute, is guilty of a felony. Now, and I agree with Ms. Dagger that statute probably comes from an older time when the law contemplated, perhaps the classic pimp who's out there with a stable of women, and the woman is involved with prostitution. The pimp perhaps provides banking protection, but also appropriates a portion of the money she receives from prostitution acts. And that's not what happened here, though certainly, like the classical situation, Ms. Corbett did provide, the location, the surroundings and I think that at least during a portion of her own allocution during the sentencing process indicated that part of her basis for doing this was she had been involved with or observed another business that didn't provide what she viewed as adequate protection for the women that were involved here, and perhaps allowed the customers to pressure them or persuade them to perform additional sexual acts that she thought was unsafe and improper, and so she builds a different business model, as it were, that she believed provided more protection for the women involved. Now, and as I said during the sentencing, the law doesn't make any distinction between sexual acts, and we do have case law out there that says, of course, sexual acts, include manual stimulation, as appears to be the primary sexual act we're talking about in Miss Corbett's situation. It's a very broad definition, and I think that broad definition, of course, in performing what we call statutory interpretation, it's important to read the statute word for word, and I agree wholeheartedly with Ms. Dagger. Part of that is giving effect to each word of the statute and then trying to discern what was the legislature's intent when they passed the statute, perhaps in an outdated time or before, we had stuff like the internet and instant messaging and stuff like that that changed every business model, not just, a business model for prostitution. And in this case, the statutory language is actually quite broad because it says that any person, and it gives also a broad definition here of how that person receives a financial benefit. They accept, they receive, they levy. Levy, of course, I associate with taxation. Of course, that's not what happens here, but nonetheless, they're or appropriates, i.e., that would be the appropriates, the pimp going to the prostitute and saying, hey, you hand over the money to me. That's not what happened here. However, in a transactional sense, and I also look down here, the person takes without consideration, that is, they're not giving anything necessarily back of value to the individual who they get the money from the proceeds of the earnings of any person engaged in prostitution. Now, read in its absolutely most narrow sense, that could include a time factor, in that the person has to commit the act of prostitution and then hand the money over in that classic pimp model that I talked about earlier, which was not what happened here. Here, the timing sequence of these men patronizing this business is they come in, they pay the money to the house, the door fee, for the room, for access. Well, and let's be honest here, they're not renting a room, to use the computer in that room to, do drafting and print out a 3D model or something. They're renting a room with a bed or massage table or something that they know contains a young woman who they believe, because of the way that they learned about this business, will provide a sexual act. And Miss Corbett did testify, she's aware of that. Was she aware of the exact act and the back and forth between the customers and the woman in the room? No, but she was aware that there was money exchanged in those rooms in return for sexual acts. And I think that taking the broader reading of this, that the earnings of the person engaged in prostitution, well, after all, the reason that the men are coming to the business in the first place isn't to get that room for an hour, isn't to lie in the bed for an hour and talk to the woman. They are coming in to, at least in some instances, and it doesn't have to be every instance. In fact, it probably only has to be one instance to fulfill the statute, in at least one instance, the person is coming in and engaging in an act of prostitution. And in my view, in light of the way the transaction occurs here and the use of the word proceeds in the statute, that, there's a broader transactional view here, and that, in terms of the customer coming in, they're going to pay $50 and they're going to give whatever they give to the woman inside the room. And the entirety of that is to facilitate or enable or make happen the act of prostitution that occurs. And I believe that that is a reasonable inference for the court to make during the plea colloquy and during the acceptance of the factual basis for this conviction here. So I don't think, in other words, that there is a time sequence that the proceeds have to be given first to the prostitute and then the prostitute has to give some to Miss Corbett. I believe that the overall basis of the transaction, even though that's not clearly spelled out in the statute, is one that facilitates prostitution, and that the earnings that were paid to Miss Corbett, that is for the room, the access to the woman. And after all, she didn't just say, hey, I set up this business with 3 rooms in it. And, there happened to be women that came in here and wanted to do, massage and et cetera services. But rather, her testimony was she formed this business for the purpose of, creating this environment where, the sexual act was provided in a way that she believed was safer for the women. So I don't think that I read or applied the statute overly broadly in this case. I think the statutory language can be read and should be read as encompassing this entirety of this transaction that involves, after all, at the end of the day, it is transactional. The customer comes in, they pay money, albeit to 2 different sources, one for the room, one for, perhaps more money in the directly in the room, negotiated with the young, the woman in the room herself. But nonetheless, the overall transaction is one that facilitates a sexual act in return for money. And Miss Corbett knew that that was occurring. So I don't think that that is an overly broad reading of the statute, nor do I think it supports the type of defect that would allow vacatur of the plea by me at this time. Thus, I'll allow the plea to stand and the motion is denied.
Thank you, Judge. 2 things. I'd be glad to do the order and submit it to you for signature, the order for denial.
Very well.
And then I can serve that to the prosecutor if that's acceptable.
We presented just a general order. It's just a standard blank.
You want to do that? Okay.
The court already has it. Yep.
Oh, it is. Okay, good.
Yep.
Okay, so the order's taken care of. Number 2, could I have a few minutes with Miss Corbett in a breakout room, please, before we sign off?
Certainly.
Okay.
Mr. Woolley?
Yes, sir.
Let's take a pick up that. What y'all decide, if any?
We're gonna center in one call for the pastor of leadership. And hopefully we'll be done before.
Dropping the one count and dropping some language in the second one, but he's completely true to using the internet. Sign in.
I don't know. It's a sheet. Some more snow and vine. Some shiny. It's done. Which is not a copy to be able to. Yeah. I'll see what I can do with now.
You gave it to her sitting.
Yeah, I'm looking at what I have last year.
Okay.
Well, that isn't symbolic.
That's our day so far.
You don't know where that landed. I'm not gonna tell you.
I'm gonna keep the 2 that I.
Yeah.
Did you have Mr. Irwin?
Mr.
So, Mr. Burden?
I didn't get that back to him.
No, it's not yet. Should be up.
Oh, no, I thought. You sure?
Maybe I didn't.
No, I have.
Okay.
Oh, here it is.
Out on the side over there.
Behind me, Irwin.
Thank you.
All right. We are back on this matter of Billy Woolley.
It wasn't meant to spook anybody. It wasn't meant to be me. But when my attorney explained to me that if I knew about it,
I might as well have been doing it myself. So that's why I'm pleading true, Your Honor. I'm just asking for a little mercy to continue to keep helping recovering alcoholics with my sober center and help my parents and just keep my head down and stay out of trouble. I'll even go to a flip phone if I need to, Your Honor. And whatever we gotta do, I just want my probation officer happy, the court happy. Just want to stay out of trouble.
All right.
There is one other thing in that. Once I got wind that the probation was trying to revoke him, you signed your order at 7:23 or something like that early in the morning. I'd called the court because we wanted to work this out. I tried to contact the probation when this first came up. It came up when they told him at one of his probation meetings. And so, you know, we immediately got on top of this. He did actually through me because I'm his agent. And, you know, he just wants to do what he's got to do and try to be in compliance with probation. And so, you know, there he is trying to take care of it. And of course, he's set me up for the last 7 days, which is required. That you know what I mean?
All right. 12 states in the probation order that was signed, do not subscribe to or use any online services, bulletin board systems, social media networks, platforms, networking services, interactive messaging apps, or photo video sharing apps through means of any electronic device, including but not limited to computers, cell phones, or gaming consoles, either at home or work, unless approved in advance by the supervising officer and the court. That's what you pleaded true to.
Yeah.
Why would you do such a thing?
Miss Johnson Block was crying out on the internet that she was struggling with her sister dying and moving to DC and was suicidal. And this other guy, Chris, was trying to make contact with her. I was working him as a 12-step call, getting him into treatment. Again, it was good intention, John, but he thought that if she didn't respond to him, maybe she'd respond to me and not commit suicide, not deal with her.
Oh, you were saving somebody's life.
No, sir. No, sir. Not at all. I was just reaching out, letting know the rooms of AA are there to save her life, not me. Your Honor, in that regard, are you familiar with the work he does through AA?
Vaguely.
Well,
I know what he's done.
Yeah, Judge, I might also.
He actually does work with AA.
I know what he's done to get himself into this room.
Yes, sir. Just throwing that out there.
Yeah, but you still have to follow the rules. I say do good things, but
yes, sir.
But the thing is on your terms. You set the rules. You can shake your head all day, but that's what you were in trouble for. It's on your terms that you decided. You try to get into people's lives and run their lives on your terms. And I told you it wasn't going to happen on my watch.
Yes.
The jury found other ones. They decided that was, and I never, juries are good. They decided that was the right thing. But then we turned around and then you've got three cases pending, the jury verdict and these other matters that you pleaded guilty to. And failure is not an option here. And you know, the pre-sentence report was loaded with information. You've made a lot of enemies in the way you act, but it's all about you controlling. You want to be in control. And sometimes supervision is important, but you've got to follow the rules. But you set the rules. You try to set your own rules on your terms, which is the tail wagging the dog. And that doesn't work on my watch. All right. So is the state's position the best interest of justice is served by continuing him on probation?
Yes, Your Honor. This violation, I don't think gets there to where I can honestly look you in the eye and say, we need to send him to prison over this.
All right. But he wants to continue on the weekend time.
Yes, sir.
No. Anything else to add?
Mayor.
No, sir.
again, thank you, sir, for your professionalism. Mr. You've always been a professional man. You ain't gonna get what you're not gonna get your way with me. You're gonna stay, you're gonna go to jail and you're gonna get out of jail when you're through with the 180 days. It's not what you want, and that's just what I'm gonna do. Whatever you don't want. Because I'm tired of you bullying everybody else, Mr. Bully.
Which is
It's just not a work. That's not gonna work on my watch. So no, he's lost his weekends.
Would you
And
consider him doing half of that and the other half on weekends?
I consider it, and let's do it. You're on my terms now. And the state, they don't make their decisions lightly, and they're not comfortable going forward with a revocation on this. But I'm going to put you in jail until we're finished with it. That's where you will sit out until this is finished. What I want is some kind of, do we have all these terms and conditions covered here? Because he looks for ways to try to find a loophole.
The only way
Because that's the nature of this beast, and I won't put up with it. I mean, you're not going to get your way with me. And so you go jail, but what else do we need to do to ensure that he doesn't try to slip through a crack here and bother other people?
No, condition 12 should be added that either directly or indirectly not to use. That way you can't try to use a friend as an excuse and say they did it and he wasn't on the internet.
You mean 12? Well, but it's not. It's pretty straightforward. It seems like it's not conditional in any way. Do not subscribe to or use any online services, bulletin board systems, social media networks, platforms, networking services, interactive messaging apps, or photo video sharing apps through means of any electronic device, including but not limited to computers, cell phones, or gaming consoles, either at home or work, unless approved in advance.
Or anyone at your direction or with. Because we can still do it and use it as like a party like we did this. Yeah.
I don't consider somebody on your behalf or under your direction and approval distancing you from responsibility for it. That's you.
Yes.
Somebody can act on your behalf, but it's still you.
Yes.
And that's enough for me.
Yes.
Because, this isn't, it's pretty clear that this is overreaching statement where you can't play the game of I'll let somebody else do it on my behalf. And the person that this was sent to, what was the relationship?
She's from what I understand, an ex-girlfriend of Mr. Bullies.
Was she a victim of any?
She's the one that sent you that email that talked about being.
I'm talking about of any filed cases.
Not filed cases.
Okay. Well, just know God loves you. The rooms of AA are also in DC. You're speaking for our Creator, are you? You're not the person to do that. You're not worthy. You got your own mess that you're trying to clean up. Don't be speaking on behalf of our Creator.
Yes, sir.
You go to jail.
Yes, sir.
You stay in until this is through.
Yes, sir.
And I want an intense probation supervision method. I just don't trust you. You've proven that.
So I'll do better.
How do you fix the victimization that you've done? How do you fix that? You don't. But you're going to follow the rules, or else you'll continue to be in confinement as long as the law can allow on my watch. If the circumstances are there, because I'm not going to let you have I'm not going to let you have wiggle room, sir. You've hurt enough people. And you're going to be held accountable. And I don't know anything. Sneezes on the sidewalk, and that's a crime. And I know. It's time. It's important. It's been more than long enough. You follow the rules like everybody else has to. Live honestly, harm no one, give each person respect. Those were written 2,000 years ago, and that's the very basis of our laws. You don't follow any of this. You are the enemy of what this Constitution stands for, the way you've acted. That is all. Okay. See you, Mr.
Thank you. I'll talk to you.
Hey, John, come on up here for a second, please. You all agree to sign these 2 dismissals?
Yes.
On that other matter?
Yes. We have Austin coming Monday, but Jimmy went ahead and did this. So Judge wants to sign that today. He can't, if not, but I've got it.
Yeah, I'm sorry, what?
Awesome.
This is too late notice, I'm sorry. It'll be 30 days. I'm here. Sure. Yeah. Have a good fun.
Yeah, yes, that's why I'm here. So we'll die. I'll have anything else, but I'm your own doctor, so appreciate you.
The good thing is,
See, sometimes this thing comes.
Because that's all they are, 19. I just like to just sit on the back. I feel something. In that shit, he's in the short. They'll see this human side. This is some of the cheapest like, hey, this is done.
Okay, here. Sign all of that. And
Just like
you're Mr. Ardmore?
Yes, sir.
Were you representing before?
I'm standby, yes, sir.
You're standby? Oh,
Yes, yes, that's why I'm here.
Well,
Because
there's another reason you're here, too. I want to talk to you, about that case yesterday.
Oh, yeah.
I don't see the prosecutor here, but on that case yesterday.
No, it's on vacation today.
On the judgment, there's going to be an affirmative finding that a deadly weapon named
Yes, yeah.
firearm was used because
Part of the nature of the
because it
case.
was it was an element of the offense they
Yeah.
found guilty. So, and I don't think I need to bring him back and make that a finding in court. I think if it's part of the elements of the crime, which is what it was. I don't think he has to be present for that.
Well, we're gonna hear Monday. We'll play his other case on Monday.
Okay.
So he'll be here on Monday, so if we wanted to just be safe, we can do that Monday. That's the check on.
Yeah, he just needs to know about it,
Yeah.
but it's going to be rendered an affirmative finding.
It's gonna be, he's planning to be put definitely funded on Monday to get his CC, current punishment with what he got from the jury. So it'll be on that one for sure.
I thought he had a third case.
There will be dismissed.
That's going to be just,
Yeah. Yeah, one dismissed, one
Okay.
in CC.
on Monday.
She's already got
Please note on that judgment, when it's fixed, on the case we had this week, there needs to be an affirmative finding that a deadly weapon, namely a firearm, was used because it's in the elements of the crime. They found him guilty. That included a firearm was necessarily used for the crime. So we have to have an affirmative finding rendered on this. And I'll do it. We'll do it on Monday when we bring him in so that it's on the record and he is made aware that an affirmative finding will be rendered and John will be here. Okay, on Mr. Ardoin. There's 6 cases, right?
Yes, sir.
Where are we on this? Or have you completed your discovery?
In the process of doing so. I believe the last time that I had brought in a paper and itemized it for Mr. Ham, those things, it was some discrepancy. He believed he gave those to me,
Yes,
but
sir.
that following week, you or Mr. Ham wasn't here. And I came and said, just with the cell phone dump on working the cell phones, he provided me with another one today. There's 3 of them, but the one he provided me today, as far as the cell phone dumps, I'm done with those. He's provided.
Okay, what else do you need?
I've itemized it. I didn't bring that.
Oh, you itemize it. So you're giving that to him to look at.
I itemized in his report. And he also has a copy of it.
Well, I don't remember, but you're gonna look at that and see what.
I've reviewed it and the state has provided all this information that he's requesting additional copies of. In my opinion, Judge, we're not gonna get anywhere. I've given him all the discovery I can give. I'm giving Your Honor the certificate of discovery that reflects that.
What is it you're saying that you don't have?
Yeah, and can I see that? Thank you, sir. The last time I was in front of you, I brought my media draft sheet and itemized everything marked with a star. He went down point by point saying what he will provide me with. Those things were never provided. The next week, he didn't come to. I think he was both of you off, if I'm not mistaken. I think that was like the 13th when we did that of this month, and the 19th and the 20th is when I came back.
No, wait, this is the 6th of March.
February. So February the 13th is the day that he itemized. Well, I itemized each and everything that I needed, and then I went to the 19th and the 20th. Those days, you or him were not here. And I expected when I came today that those things that I asked for would be given. He claims he's already given me those things.
Here, what on?
Now, one thing I did concede to is the interview of 10/25/22. I told him that day I did in fact see that interview, but I would like to view it again. Then after that, there's Chris Daniels' body worn camera. That's the arresting officer. Those are 5 of those, I believe. Yeah, there's 5 of those. And also.
And you've never seen those? You don't have them?
They've been provided.
Okay, what am I supposed to do? He says they provided, you say no.
Everything
What am I supposed to do?
Everything is easy verifiable.
What am I supposed to do?
At some point in time, we've got to move forward to trial. I disagree with him. I'm not going to keep playing these games. I want to move forward and resolve this matter. He can raise whatever he wants to. I've got plenty of notes that has reflected that he's been given the opportunity to see those items. I mean, we're just going to constantly be spinning our wheels if we continue to believe
before
this position and not lie.
At the trial, before you present it, he's going to get a chance to review it.
I've got it. It's not like it's not available. It's just I'm tired of delaying. I want to move forward.
Your Honor, they've had 3 years with this information. I've had less than 24.
He's already said he's provided it to you.
The records will prove that I itemized and he's not provided me since then. Each time I came here, I act the same thing each and every time.
He says he's already done that.
I want to correct what he has stated. That there's a time when we stood before you on the record in February.
Let him finish without interrupting. Go ahead.
And the result of that communication, it was determined that all he needed was a copy of the cell phone dump information, as well as an opportunity to review the photos. I had all that set up. He's correct. I was out of town, but Mr. Laird stepped in, gave him an opportunity to review it. It turned out that the cell phone information wasn't able to be opened. Mr. Laird worked on trying to get it resolved for him that day. It wasn't done. I've completed that today, as he's already represented.
What is it that you're saying they didn't provide you?
These things that I.
No, what things? Read them to me. So
Yes, sir. Shannon Ardoin, my interview for 10/25/22.
He's already reviewed it. He wants to.
Hold on.
Don't correct me, sir.
Hold on. What's next, sir? What's next?
Chris Daniels body cam. There's 5 of those. That's 2 hours worth of information. Chris Daniels.
Hold on. His body
cams. Footage.
And that's how long?
That's 2 hours worth of footage. It also has 3 same Chris Daniels vehicle camera, 3 files.
Hold on. Chris Daniels. One at a time. I gotta write this down.
Yeah.
Video cameras?
Yes, sir. His vehicle cameras. His body cameras and his vehicle
cameras. Go ahead. What's that?
CID, BFD, accelerant containers. Those are 12 images of those.
All photos have been provided to your investigator.
Have you talked to the investigator?
Not in groups. I think we run out of funds because before I even got any of the discovery.
Hold on. What are you saying? No.
Haven't run out. There was no set fund thing for her.
Or wasn't?
No. So when you say things, make sure you're accurate about.
Well, it said 25. Speaking what she told me that when she.
Who's she?
Protected the court with an invoice.
Yeah, exactly. The invoice. She hasn't provided the invoice yet.
That doesn't mean she's done.
Well, I haven't seen it in weeks.
What else? What else is that in?
Video Park Del Mall security cameras.
Our position is he's had an opportunity to review that as well, Judge.
What else?
Toxicology report from the pathologist, Stephanie Group.
That should be included with all the autopsy information already provided.
It was not.
What else?
I believe that Your Honor screamed that before he got.
What else?
A copy of arrest warrant. All communications between T-Mobile and Beaumont PD and any other state agency concerning the location data of the victim's cell phone.
Say that again.
All communication between T-Mobile and the Beaumont PD or any other state agency concerning location data of the victim's cell phone up to 10/7/2022.
Okay.
Judge, that's not a part of our media sheet. He's not listing information that he's requesting.
Okay. Or do you have that?
I don't have that.
Okay. He doesn't have that. So he can't give it to you.
It should be a part of discovery, right? If the phone.
He doesn't have it. What's discovered?
Okay.
I don't have it. What else? Is that it?
That's it.
Okay. So we've got the 10/25/22 interview, right?
It's on one of the discs. I've already looked at it again this morning.
Okay.
It's a bit.
Okay.
You won't let him.
He's saying he looked at it this morning.
I know it's been provided to him to review.
And he says,
all of our
where
notes.
is it exactly?
I've got it in information here today.
Okay. It just, can you re-provide it to him? I know it's a pain.
Judge, I can continue to re-provide. I'm wondering when we're going to stop is my frustration.
We've got 2, 4.
Tell me what it is that you want me to show them again.
I've got the 10/25/22 interview, the Chris Daniels body cam, 3 vehicle camera off the vehicle, 3 vehicle camera.
Of Chris Daniels, the rest of them.
12 images, and those are
That's been provided to his investigator.
Right, do it again, please.
He sent to me, Your Honor. I'm actually.
Listen, I'm just trying to get this done. It's y'all, there's no way I can figure out. He says one thing, you say one thing. What I'm going to do is get it resent to you. Okay.
Okay.
This video Parkdale Mall camera, the toxicology report, arrest warrant. There's 7 things there. And then this last one, that's
hang on, Judge, I'm catching up. Please.
There's going to be 7 things here. 7 sets of things.
So what I have in notes that we've all been working with is his interview.
October 22.
Yes, sir. October 25th, 22. I have the next matter is Officer Daniels'
body cam.
All the cameras. I have the 12 photographs for the accelerants.
Hold on. 3 Chris Daniels vehicle camera.
All those. I'm going to include all the Chris Daniels camera work, which includes body camera as well as his patrol.
Then 12 images.
12 images. I know he's requested the security videos
of Parkdale Mall.
Yes, sir.
Toxicology report.
Okay, now that's not on this sheet, so that's why I wanted to stop. The toxicology report. Go ahead.
And arrest warrant.
Yeah. The BPD license plate reader. That's kind of, you know, that's what he said he provided it to my investigator.
Okay. What else did you say?
The BPD license plate reader report. He said he provided it to my investigator.
No, I said I provided photographs to your investigator.
Yes, sir.
I will check the notes about what's been provided to the investigator as well.
Your Honor, the bottlenecking of the information is the problem. It's not me. If he would give me the things that I asked.
You're going to the arguing about it isn't going to get it done. I've just said he's going to. I've done this for 20 years and I never have problems. I've never had problems with this organization. And 600 plus jury trials. This is the first time I've heard of something like this, and they've always been overboard in providing information to the defense. They've always been. So it'll get done.
Okay, thank you.
All right. Anything else?
No, sir.
State, defense. Okay, we're in recess on that.
Thank you.
Anything else? I think. What else? Yes. So what else? Anything else? If not, we're in recess. Thank you. See you.
Rajabi Riza, or Riza Rajabi versus Vance Wicks.
Good
morning, Your Honor. Good morning. Mr. Rajabi, can you get yourself unmuted? Is he at ours? Or he's at 14.2. All right, can you, yeah. Okay, I see him. Mr. Rajabi, hold down the space bar on the computer. Just hold it down when you're trying to talk. There you go.
Can you hear me?
I can hear you.
Okay, thank you. Good morning.
All right. So this is a non-payment case. How much are you claiming is owed?
Excuse me, would you please repeat your question?
You filed a non-payment of rent case. How much are you claiming is owed?
On the paper that you have in your folder, it is $4,983.92. However, last night I was doing all the touch-ups to get ready, and it came to $6,083.92.
$6,083.92?
Yes, sir.
Okay, does that include your calculation? Does that include March rent?
It includes everything, rent.
It includes everything. All right. Mr. Wicks, what do you have to say about that?
I have to say this person, I've already filed a police report with Officer Cammy. This person has nonstop harassed me. Actually, I don't even have a lease with him. I had a lease with his daughter, and he came back from Iran, and she just kind of pushed him on me. And this guy has been 100%
Who pushed him on you?
I mean, saying you got to deal with him, not me anymore. So, but he's been nonstop harassing me. He comes up constantly unannounced. One day after the first day that I missed, he was at the door screaming at me, threatening me that he's going to turn the electric off and everything else. And it just...
All right. Okay. So let's back up because Mr. Rajabi, we've run into this before. Who is the lease with?
It's not with him. Sorry.
Mr. Rajabi?
I was in I want to make it really short. I was in my country, my native country, visiting in the summer, and unfortunately the United States and
Okay, that's a long answer to my question.
Okay.
My question is, who is the lease with?
Is the lease
with you?
The lease was signed by my daughter.
I have a copy of that too, Your Honor.
When I came back from my native country, my daughter says that, you have a tenant, and from now on, he's going to pay you the rent.
Who owns the property?
I own the property and the bank.
But the lease is between this gentleman and your daughter.
Yes. May I please? I did tell him that I would like you to fill out an application form with your social security number so that we will have a lease, a new lease. He refused to do so.
Well, what's wrong with the lease he has?
Excuse me, Your Honor, my daughter just called me. I wonder if she's going to say something about this whole situation. Would it be okay if I?
No. We're not going to do it that way.
Okay.
Here's what we're going to do.
Okay, go ahead.
I need all of the proper parties here. That's going to include your daughter. If you want to come down, you come down, and Mr. Wicks. So I'm going to adjourn this out 1 week.
May I?
To March 13th, 2026 at 3 p.m. That's an in-person hearing. So everybody needs to come down to the courthouse. Bring all of your paperwork and everything. I'll take a look at it and we'll figure out where we're going to go.
May I make a motion, Your Honor? May I make a motion?
May you what?
I would like to make a motion. May I?
Make a motion?
Yeah. Make
to do what?
Could you please ask him to at least put in an escrow account that the rent he owes me so far, when we come back, it's going to be up your judgment what is going to happen to that money. Because I think he's dragging his feet not to pay rent. and stay in my house.
So first of all, I can't order that at this hearing.
I see.
All right? I don't even know. I heard what's owed or what's been said is owed, but I don't know that I'm talking to the proper party in interest, which may be your daughter.
Okay,
So I'm not going to do anything. I'm going to wait, see what the lease says. You and your daughter need to come down with a ledger that's going to show me the amounts that are owed, and then we'll figure out where we're going to go from here.
okay. May I please say one more thing?
I
Utilities.
can't stop you. Go ahead.
I'm sorry. Your Honor, utilities are not in his name. He's supposed to put them in his name. And he keep telling me, if you shut off the utilities, I'm going to take you to court. I have no intention of shutting off the utilities. I'm a landlord. I know what happens if I shut off the utilities on him. And DT has contacted him, and he's not anything but utilities.
Okay, there's nothing I can do with that.
Your Honor, may I say something? May I ask
I
something?
really would wish you wouldn't, but go ahead. He's got to say something.
I just want to know what I got to do to have an attorney represent me. I mean, can I have one appointed?
Okay,
to me,
you
or-
can. Okay, so you're going to try to get an attorney. You
I'm
can call
just-
legal. Okay, hold on, folks. You can call legal services. You need that number?
Yeah, can I get it?
Yes, it's area code 734
734.
66. That's Legal Services of South Central Michigan.
South Central.
Okay, you can call them. The other place you can call is the Michigan, University of Michigan Criminal Civil Litigation Clinic. Their number is, I just had it. I don't have that one memorized. It's area code 734. Hang on. Area code 734. Okay, so you can call them. I'm gonna mark the file that you may get an attorney. And we'll see you guys next week at 3 p.m. in person. I can't wait. Thank you.
Thank you.
All right.
You're welcome. Have a great day, sir.
You do the same.
I'll try. I had to leave
All
work
right.
for today, so. Oh, one more thing. I have never been served a process, period.
Pardon?
This person right here has gone through my mail. I got a picture of it. He took my mail out of the mailbox and put it on my car. And furthermore, I just getting off work yesterday happened to notice this thing in the mailbox, which
what thing?
Less than this summons, less than 24 hours is what I had. I got off work at 2 o'clock yesterday to see this. I had to take off work today. And nobody ever, I haven't seen a process server. I get random people banging on my door with this guy screaming all the time, constantly, to the point to where I won't answer the door. Your Honor, one more thing and I'll be quiet. I've been in therapy for PTSD for over 2 years now. I've been in therapy for PTSD for over 2 years now. My doctor's Dr. Brower. I just had an appointment Wednesday. This person has gone above and beyond, threatening me and making my life a living nightmare.
Oh my God.
And he's not even, we don't even have a lease together. So please,
All right.
I need help to.
All right. So first thing you're going to do is try to reach out to attorneys.
Yes, sir.
And then, Mr. Rajabi, I don't want you over there in the interim week. Do not go over to the property.
Thank you, sir. I
Your
appreciate
Honor,
hear
when
me?
you put me, when you give me under oath, I will tell you whether he's telling the truth or not.
Okay, but I'm not there yet.
Okay.
I just need to keep you two apart from each other for the next week until you're in person before me. That's all I need to have happen. Just don't bother each other.
Sir, I haven't seen him in 2 months. 2 months, Your Honor.
That's a lie.
I swear
He's
to
there
God.
every single day.
Every single day.
Yep.
Okay. Thank you, Your Honor.
Really? Are we done now? We'll see you next week. Stay away from each other until you get to the courthouse. You understand that? That's an order.
Yes, sir.
Does that mean he's gonna be on the property still?
Just shut up.
I'm sorry, Judge Simpson.
No, don't tell him to look, both of you. You want me to bring you down here today? Because if I bring you down here today, it's not gonna end well for anybody.
Okay.
No, sir.
Didn't think so.
Thank
So
you.
stay away from each other, be quiet, have a great weekend. We'll see you next week.
Thanks a lot, Judge. I'm sorry for all the.
Bye,
inconvenience.
goodbye. Said, oh my God.
DNA District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge J.
You may be seated. Court does call the case of the people of the state of Michigan versus Sharone Moore.
Good afternoon, Your Honor. Katie Rizzo for the people. Good afternoon, Your Honor. Ellen Michaels on behalf of Sharone Moore, who's state your name.
Sharone Moore. Thank you.
Christine Pajak also on behalf of Sharone Moore.
All right, thank you. You may be seated. All right. So date and time set for a Frank's hearing, but things have changed. And even before you go on, I just want to express the court's appreciation for the hard work of counsel going through. I know it may have been a delay for the people that were waiting to see something, but your efforts were greatly appreciated. Mr. Simpson.
Your Honor, thank you, and I appreciate the opportunity to address the court. First, allow me to apologize to the court and counsel. I was needed unexpectedly elsewhere in another county on a special prosecutor case this morning that went perhaps a little bit longer than expected, and then as life unfolds, I was rear-ended in a gas station parking lot. Everybody is fine, but I really appreciate everyone's patience, and it was not intentional. Judge, I appreciate the opportunity to address the court about what has transpired and where we have arrived. This case, as is true with many cases, Your Honor, is alive and sort of moving and breathing. Investigation has been ongoing. An exchange of information has also been ongoing. As a result of all of that, where we have arrived based on what we now know is that we feel the most appropriate charges to address the defendant's behavior on December 10th of 2025 are two additional counts 4 and 5. We would be seeking to add a count of what we call malicious use of a telecommunications device in the context of a domestic relationship, and then an additional count of trespass. Those are, as Your Honor is aware, misdemeanor matters. Your Honor, we have arrived at that as indicated based on a thorough review of the additional evolved evidence and investigation, as well as after consultation with pursuant to our obligation of the Crime Victim Rights Act, consultation with the victim, largely through her representatives in this matter. Your Honor, one comment I would like to make specifically about the additional count of malicious use of a telecommunications device in the context of a domestic relationship, as this court is aware, but I would like to be clear for the record because of, I know, docket and calendaring purposes. Your Honor, we did not at the time of issuing initial charges in this matter, nor do we believe now after additional evidence has been presented to us, do not believe that there is sufficient evidence to prove a count of domestic violence in this matter, not historically and not what happened on December 10th. So we are obligated, as this court is well aware, legally and ethically and morally to not charge that which we do not think we can prove. What we do believe the evidence supports is criminal misbehavior in the context of an intimate partner relationship, and that is why that tag on is on the malicious use charge. Your Honor, it is my understanding that pursuant to adding those counts, that there will be a plea as a result of that, but I leave that to counsel.
Did you want to say something?
Yes, thank you so much. I'd like the record to be clear that the negotiated disposition involves a dismissal of the 3 charges that had been charged. That was not mentioned in the recitation by the prosecutor's office.
That is absolutely correct. The end result of where we land by adding on the counts is that my best understanding is that the defendant will enter a plea to those additional counts, and in exchange for that, we will absolutely dismiss the originally charged.
And that would be an entering of a no contest plea to count 4 and count 5 with the dismissal of count 1, 2, and 3.
All right, very good.
Thank you.
The court does have before it a plea agreement form that indicates that the defendant will be pleading no contest to the charge of malicious use of a telecommunications device with domestic relationship tag. That is a misdemeanor punishable by up to 6 months incarceration. He will also be pleading no contest to the charge of trespass, which is a 30-day misdemeanor. Upon his successful no contest plea to those charges, counts 1, 2, and 3 will be dismissed. That is the court's full understanding of the agreement. There is, however, one other thing that should be mentioned, and that is with reference to sentencing. The court is going to be given full authority, if the court deems it necessary after a review, to sentence under a deferred program. That is the court's understanding.
That is also correct.
That is correct.
All right, very good. Mr. Moore and counsel, if you could approach the podium, please. Okay, gotcha. And if I may have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give the truth, the whole, nothing but the truth, so help you God.
Yes, sir.
What's your name, please?
Sharone Moore.
Mr. Moore, it is this court's understanding that you are going to be pleading no contest to 2 misdemeanor charges. The first charge is the added count 4 of malicious use of a telecommunications device involving a domestic relationship. That's a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
And also the added count 5 of trespass. That is a misdemeanor punishable by up to 30 days in jail and or a fine not to exceed $250. Do you understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about a no contest plea I have to make sure that you understand. First thing is that it first of all means that you're not further desirous or wanting to contest these 2 charges. You understand that, sir?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea, counsel.
The basis for the no contest plea is civil liability.
Potential civil liability. All right. Very
Yes,
good.
civil litigation.
Got it. Some more to the charge of. Oh, let's do it this way. Find the form. To the charge of malicious use of a telecommunications device, how do you plead?
No contest.
To the charge of trespass, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
I don't think he has executed any advice and rights form, has he? I think he did, actually. I don't have it.
I believe he did at arraignment.
At arraignment. Do you recall that, sir?
Not off the top of my head, sir.
Pardon?
Did you-
Not off the top of my head.
I have one that I printed up just so we can continue. I did go over the advice of rights form with my client yesterday. So him signing it now is acknowledging that he did review it yesterday.
All right. Is that correct, sir?
Yes, sir.
All right. I'll let you. Did you have any questions regarding any of the rights that are contained on that form?
No, sir.
All right. You understand that by pleading no contest, you're waiving or giving up the rights that are contained on that form.
Yes, sir.
Particularly the rights that are contained under paragraph 5. You'll see a copy on the podium, which are your trial rights. You understand that you're giving up those?
Yes, sir.
All right. You understand you're giving up your right to appeal?
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
The court has been provided and has reviewed thoroughly Pittsfield Township Department of Public Safety report for their case number 25-25629. Counsel, any objection to the court having reviewed that report?
No objection. No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these two offenses. Sir, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit any misconduct as defined under the Michigan court rules, you would first of all not be entitled to withdraw your plea. You understand that?
Yes, sir.
And also the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Is counsel aware of any threat, promises, threats, or other inducements which have led to this plea?
There are none.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Court has.
Yes, Your Honor.
Court will accept the defendant's no contest pleas to counts 4 and 5. Counts 1, 2, and 3 are hereby ordered dismissed. A pre-sentence investigation and report is ordered. Sentencing in this matter will be, will April 13th work for the parties? I have April 13th or April 20th at 11 a.m.
April 13th works for the defense.
Much better.
Well, hold on once. These are Mondays. I don't want Monday. I don't want a Monday.
You want a Wednesday?
I want a Wednesday. Okay. Hang on a second. April 8th, will that work?
I'm not available. I'll be in trial in Oakland County.
The sentencing will go smoothly. No. All right. April 22nd in the afternoon.
That's good for the defense.
Will that work for the people?
Judge, I personally will likely be unavailable in a trial, but it sounds like my office could make certain that it's covered.
Well, you've been here from the beginning. We might as well try to make it work for you too. Give me a special day then. Will the April 14th in the afternoon work?
That should work.
I'm checking. April 14th works for the defense.
April 14th, 2026 at
2 p.m.
2 p.m. Before me. Anything, Esteban?
Nothing.
Yes, as to bond, we are asking that the bond condition of a GPS tether be removed as a condition of bond for the following reasons. The tether was placed when it was the understanding that the charges my client was facing was a felony and a stalking charge. Now that those charges are dismissed and the narrative of my client being having a history of violence and stalking has now been proven to be false. It's our position that the tether is no longer necessary. There is still in effect a no contact order by my client to the complainant or by any third party to the complainant. He will absolutely abide by that no contact provision, and he has no intent to by himself or anybody else to contact the complainant.
All right. Any response from the people?
I will say that I am comfortable leaving the matter of the tether in the sound discretion of the court. I will reiterate that our victim's most fervent desire is that the no contact, either direct or through third party order, remain in effect, and that is her highest priority and therefore ours.
All right. What I'm going to do, and that provision regarding the no contact either by the defendant or a third party does remain in effect. I'm going to, at this time, however, deny the request for the removal of GPS tether until such time as The defendant has been interviewed by probation, and then I will make a decision on that based upon a recommendation from probation. All right,
Thank you for that consideration.
thank you. Anything additional?
No, Your Honor.
Fantastic. Again, thank you both for your hard work on this and for getting it done. Thank you.
So much.
Court stands adjourned.
Oh yeah. And happy birthday to Rhonda. Happy birthday to you. Oh yeah. That's all we got, ladies and gentlemen. I'm your lone wolf Usul. And that was the conclusion, for the most part, of the Sharone Moore saga. We'll be watching for the sentencing, but you know, we can all pretty much guess how that's going to turn out. The plea is, as can be expected. The guy took some lumps for all the stupid stuff he did, as should be, but I hope he gets his stuff together and gets his life in order and makes some better decisions in the future, like we all need to do on a daily basis. Oh my Lord. And next week we will be looking for that landlord-tenant case in person in front of Judge Simpson. And you always gotta love it when Judge Stevens is yelling at the bullies. Ladies and gentlemen, that's how it goes. That's how it goes. And thank you so very much for hanging out with me this evening. We are redirecting over to Hutch, who is live and in person again tonight with some good stuff playing. There's a link right there in the chat. And I do have a redirect set up, so whether it works or not is anybody's guess. But for now, I'm going to say thank you very much for hanging out with me. I do this every weeknight, same wolf time, same wolf channel. But tomorrow, which is a Saturday, we're going to do a weekend review at 11 a.m. Central Time, noon Eastern. So come on by for brunch. I have about 2 hours and 40 minutes of freaking crazy court stuff that we did not get to watch on the nightlies. So we're going to go back through it tomorrow. And one of the cases is something that happened in DeSanto today that I thought was really interesting. So come on by and tune in with me. And for now, go tell Hutch I said hi. I'm your lone wolf Usul, and I am out. Oh yeah, by the way, I need to say a special thank you to Jermurgerg, Sovereign Legal Encounters, and Kirnoth. Thank you so very much for your support and your super chats this evening. It means the world to me. And having everybody in chat in general just means the world to me. Every view is important. Every like is appreciated. Every comment is crazy and cool. See you next time. Rub-a-dub Hutch. Healer.